Hey YouTube family and GN subs, we got a great case from the Supreme Court. Loper Bright case is amazing. We're going to talk all about it. You probably have heard a little bit about it. I've looked at some of the videos. Horrible stuff. They make it so complicated. Look, it's not that complicated. I'm going to tell you about the case. I'm going to tell you why it's so important to immigration, and we're going to talk about other things as well. I got a few good updates for you. Always good news, right? Those of you who are new to the channel, my name is Humberto R. Gray, attorney at law here in sunny Southern California, and I've been doing this for quite some time, bringing you good news. I always tell people, you want bad news, you got to go to the other channels. This one, you get good news, and boy, do we have some good news with this Supreme Court decision. All right, we got a lot to get to, so let's get at it. All righty, you've been hearing about Chevron. Let me tell you what Chevron is. Chevron is a decision from 1984 that says if you have a regulation that is ambiguous, the courts will defer to the agency what their interpretation is for that regulation. For example, immigration, right? There are regulations, and we'll talk a little bit about that later, but if a regulation for immigration is ambiguous, the courts traditionally, they defer to immigration. Immigration would win. So we have to talk about stare decisis. This is an important concept in law. When I was in law school, we studied it. What it is that generally the courts will follow precedent. What that means is the courts will follow their own prior decisions. And so in prior decisions, the name of the case, Chevron, they gave deference to agencies, right? Loper Bright overturned 40 years of precedent. I mean, flipped it on its back and says, no, we're not going to give deference to agencies now. The courts are going to take jurisdiction, and there's a test that one must follow under Loper Bright, and that test is as follows. Number one, Congress gave authority to the agency to act. For example, Congress does give USCIS authority to promulgate regulations, all right? And then number two, whether or not the decision of the agency is reasonable. So that's the new test. It's not blanket deference to immigration anymore, right? So what happens in immigration is you have a statute, right? The statute is the law that Congress provides. Then Congress says, okay, USCIS, you can go ahead and make regulations regarding the statute. I did this in 1990. I assisted USCIS in drafting regulations for the O and the P visa, visas for extraordinary ability individuals, because I had clients, that I represented in that area. And so I knew what the process should be in any event. So we did draft regulations for the statute. And the way that it used to be is if there was an ambiguous part of that regulation and it's litigated, the courts would give deference to USCIS time and time again. And there were some horrible decisions, folks. There would be some decisions that interpreted those regulations that were just mind-blowing. And the courts would say, yep, USCIS has deference. Sorry. Right now, it's not going to be like that anymore. Thank goodness. If there's a bad decision, we immigration lawyers, we are going to appeal it to the courts, and the courts are going to say, nope, USCIS, you do not have deference. You have to show us why your decision is reasonable. That is huge, folks. I cannot wait to litigate some of these cases, get them up to the district courts and the courts of appeals. I think this is wonderful for immigrants. This is a game changer, folks, and I am so pleased that we're going to be able to litigate. All right, another bit of good news. I have a new access portal for immigrants that are in removal proceedings. I put a link in the description box below. You can go here. This is wonderful, folks. You can go here and you can find out your court date. You can find out what's happened in the case. You can get the history of the case. This is great. And all you would need is to register and provide your A number. That's the number that you got when you were initially in removal proceedings. It starts with the letter A, and then there's an 8 or a 9-digit number that follows. That's the number you put in. It's great. Go to it if you're in removal proceedings and get information with regard to your case. All righty, we got another bit of good news. Automatic extensions of I-765 work authorization. If you have a timely filed extension of your work authorization before August of 2025, you will receive 540 days automatic extension. Make sure that is filed on time. That's before the expiration of your previous EAD. Also make sure it's in the same category, right? So this is wonderful news taking you into 2025, folks. That's really good so you don't lose your job. You make sure you get your receipt. On that receipt, it's going to show automatic 540-day extension of your work authorization. Alrighty, so this is an interesting story. Ravi versus US. ICE set up a fake school for individuals to go, and they were issuing I-20s as a sting operation to get immigrants and remove them from the US. Horrible. These students came into the US, they thought it was a real school. They actually paid fees for a semester, upwards $12,000. Well, guess what? The court said, no, you can't prosecute these kids. You set up a sting operation. This is not right. If you were one of those students, go and check out the class action in Ravi versus US. You may be part of that. Get your I-20, get your F1 student visa clean, and get to a good school and get your studies done in the US. Get the fraud removed from your case. All right, YouTube family and GN subs, thank you so much for watching GrayLaw TV. As always, go to my content. I got some real good stuff, folks, and I'd like to share with you a post from last week, okay? This post is great. It means a lot to me that you GN subs, you listen to my content. You know that I like to spread positivity. I just hope I make a smile in your day. And thanks again, and we'll see you next time.